The Senate Committee on Criminal Justice will come to order. Clerk will call the roll.
Chair Flores,
Present.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
Here.
Okay, no quorum.
A quorum is not present, but as members arrive, we will enter into the roll. There's a lot of committee meetings going on this morning, so you'll probably see a lot of going in and out, trying to carry out the Senate's business. But we'll do our best to lay out the bills we have to. Welcome, Senator Betancourt. You always count, Senator. Now, the purpose of today's hearing is to take up and consider items related to sexual assault and human trafficking, better protection of victims, and enhanced penalties for certain crimes. So the protection of Texans from falling victim to sexual assaults and from being trafficked and victimized in unspeakable ways are keystones of our justice system, both for the victims of these crimes and in ensuring safety in our communities. No one should have to suffer the horrors of these crimes. Among the bills on our agenda today are measures designed to close loopholes in our current laws to better protect victims, to improve reporting and evidence collection and testing, and to enhance victims' rights of family violence and stalking. Other bills would enhance punishments for the murders of our children and continuing our efforts to crack down on thieves who are stealing fuel. Make no mistake, the people who are committing these crimes should be behind bars and not free on our streets, victimizing more Texans every day. It is the intent of this chair to lay out the bills one at a time, take invited public testimony, then vote each bill in the order of presentation if we have a quorum. If you intend to provide verbal testimony and would like to register a position on one or more bills, please register at one of the kiosks that are located behind the committee hearing room or throughout the Capitol, and public testimony be limited to 2 minutes or at the discretion of the chair. Members, does anyone have any statement you wish to make before we proceed? The chair lays out Senate Bill 990 and recognizes Senator Betancourt to explain the bill.
Thank you, Mr. Chairman and members. In June of 2024, a 12-year-old preteen, Jocelyn Nungary, was murdered in cold blood in Harris County, Texas. Under current law, their killers cannot be tried with the punishment that the Harris County District Attorney's Office at the time deemed just, the death penalty. The limitations failed to provide justice that such crimes demand and should be considered by a jury, by prosecutors, and by a judge. Forensic evidence later identified that Jocelyn was brutally raped by her killers. This was the sole reason that the prosecution could pursue the death penalty. I found out about this horrific crime, and my first question, Mr. Chairman, was asked why the death penalty didn't apply in this case. And the answer was that currently a child under 10, the murder of a child under 10 in Texas, it does qualify for the death penalty, but our children from 10, preteens, 15, Senator Hagenbu, don't have this protection under law, which I consider important. Now, I first met the family at Mattress Mac's funeral, or actual memorial service for the Nungarys. And they're a large, well-knit, impressive working class family that was thrust into tragedy because of two killers that were brought into the country by the failed policies of the Biden administration. And I began thinking, is there anything we could have done to prevent this? The obvious answer was that the federal government was the one that let them in the country. And then I started thinking, is there anything that we can do to make Texas not only that shining city of the hill, but a beacon that says to criminals that if you kill our children, it's the one time that you could receive the death penalty. Now, I'm a Catholic, so I don't come to this decision without great thought and prayer, because as we all are, we're torn between the Old Testament, eye for an eye, and teachings of Jesus in the New Testament. But I come back to the biblical story of the slaughter of the innocents. And what is our response to the slaughter of the innocents in the 21st century, 2,000 years later? And I feel that for the justice of the family, for Jocelyn's mother, who's here with us, for all those in the future, that maybe this penalty could save. And I feel like that this is the one time that I'll be signing on to a death penalty bill, because I feel there's no other tool that we have in the state that could try to deter this crime and subsequently increase children's safety. Mr. Chairman, members, I'm happy to answer any questions.
Members, are there any questions of Senator Bettencourt? Any questions? Thank you for bringing this bill forward, and this case is heinous. Victimizing our children, killing our children is not acceptable in any form or fashion, and we look forward to having this bill progress. The chair now calls Alexis Nungary and April Aguirre.
Good morning, everybody. Thank you for having me here to testify and provide my daughter's story. Jocelyn Lascelle Nungare was a Christmas baby. She was born 2 days after Christmas. She loved all things magical. She had a love for music. I truly believe she was an old soul. She was beyond her time. Incredible, very creative. She had a love for animals. Her biggest dream was to save every single animal ever. She wanted all animals to have a home, and she was the kindest friend any friend could ask for. Very sweet, very honest, with her own spunky attitude and quirkiness. She was incredible. And 9 months and 1 day, today, she made a decision that would change the rest of her life and our family's life. She went to the store to go get a soda and was encountered by 2 illegal Venezuelans who were released in the Biden administration, and they should have been detained, and they were not. And they encountered Jocelyn one evening, and they lured her over to a bridge and were with her for 2 hours. She was strangled to death. She was brutally raped. She was left with no pants on, and she was bounded from her ankles and her wrists, left there to rot. Thankfully, a Samaritan found her the following morning, the same morning actually, just hours later. I had to go with my family to the courtroom to make sure they got an adequate bond, and I had to make sure that the prosecution team was able to fight in our defense to provide death for these individuals as a charge. I don't think just because she's 12 years old that she shouldn't be eligible for that. 12, 14, 16, they should all be counted. All of the children, they're supposed to be our future. They're supposed to make us proud. And when we can't protect them, that's a problem. I think all children should be accounted for regardless of their age, because they are important and we need to keep them safe. And I'm here to testify, to plead as a grieving mother who is standing strong and being brave and trying to help change and make change for the better to help protect all children. Thank you so much for your time.
Thank you. Senator Bettencourt?
I'll wait till April testifies.
My name is April Aguirre. I am the aunt of Arlene Alvarez. Arlene Alvarez was shot on her way to dinner on Valentine's evening on February 2022. Since that day, she was 9 years old. She qualified, her killer qualified for capital murder because of her age. Since then, as a family, we have vowed to help children in our area. There's so many murders where we come from in Harris County that we can't help everybody, but we choose to help children. The story that I have for you today is of Maria Gonzalez, a migrant child who was here with her migrant father living in Pasadena, Texas. She was learning to speak English and she was excited to start school in August. A few days shy of starting school, she was killed by her neighbor, who was also a migrant. Her story resonates with me so much because I see myself in her. From migrant families and trying to make it and trying to learn this culture while saying goodbye to our culture from other countries. She was in her apartment by herself. Her father went to work. He is the exact image of the type of migrants we want in this country. Extremely hardworking. This predator saw his schedule and took advantage of the fact that her father worked long hours on the weekends. Maria was 11 years old, and her uncle and aunt lived just 2 doors down, but they couldn't save her or keep her safe. This man knocked on her door. She recognized him, so she opened the door. He pushed his way in, and I made the mistake of helping Mr. Gonzalez clean up the apartment where Maria Gonzalez fought for her life. It was torn to shreds. Pillows, glass. This little girl fought so hard. It looked like it had been ransacked by 8 people. At the end, Maria lost her battle to this man who took advantage of her sexually and tried to dispose of her body by putting her in a trash bag. The police say that he was spooked, so he didn't remove the body from the apartment. He put her under the bed. When her father couldn't reach her, he came back home. And they searched and they searched. They called the police until they found her body under the bed in a trash bag. She had been tortured, bitten, strangled, raped. But because she was 11 years old, the individual that did this to her didn't automatically qualify for the capital murder. Therefore, was offered a bond. So just like Jocelyn Nungare, we stood with their family to ensure that these individuals got adequate bond. But Maria Gonzalez is a child. If we do not hold accountable the predators that prey on our most vulnerable communities, what message are we sending? These crimes, even if there was no sexual assault, should qualify for the death penalty with a capital murder charge. Now Maria Gonzalez and Jocelyn Nungare's case face a capital murder because they were able to prove months down the line that there was sexual assault. Even though it was clear to the police, that's not enough. They need to go through the medical examiner's office to determine that and then wait months before the DNA came back to prove that there was sexual assault done on the child. And only then, months later, will they qualify for capital murder, which changes the game when it comes to bail and bond. These individuals should be never given the opportunity to get out. Now, the individual that killed Maria Gonzalez had ties to the dictator in Venezuela, Maduro. So there was concerns that he could bail out, and this family should have never, ever been worried about him getting out on bail because the dictator could have put up the money. I appreciate everybody listening to this bill. We need to hold our predators and monsters accountable. And if we don't do that, if we can't hold the worst of the worst accountable, then what are we doing here? Thank you.
Thank you for your testimony and our deepest condolences again. And we thank you for being here. I know this is extremely heart-wrenching and difficult, but I will assure you that we will work as hard as we can with you to assure that justice is done. And that's what we're here for, is justice, criminal justice. Senator Bettencourt.
Thank you, Mr. Chairman. First off, Alexis, you're one of the strongest people I know. And I've gotten to know Jocelyn through you and through your family and through what you said about her. And the fact that I think your daughter was your best friend. That's my guess. I have never asked you that before. But that process of losing your child that you had at a young age and maybe your best friend, it steeled you to come in today to say that there is just horrific evil out there that has to be stopped, and that the slaughter of innocents has to stop. And if you could say one thing for Jocelyn in her memory, what would it be today?
To keep fighting. She somehow, some way, always knew she was going to be famous, and I will make it my legacy to live her legacy on and make her dreams come true, even if she's not here physically.
And April, with Maria's case, the same thing, an 11-year-old. The pattern is the same here, that we have, in both cases, obviously, both our heroes fought for their lives and lost. So what do we say to the rest of the Capitol? Because this is going to be a difficult vote. I'm just going to recognize the obvious, okay, for legislators on both sides of the Capitol. This is not something that we do every day, which is to decide to extend the death penalty or the capital punishment laws. So if you had one message to give to everyone that's listening in the Capitol, what would that be?
If these monsters don't deserve the death penalty, then I don't know who does. Maria came here to this country with an American dream, just like my family did. I was able to fulfill that dream. I speak both languages proudly, and Maria's dream was shattered. If we don't hold those people accountable, then who is eligible for death? If you kill one of our children, regardless of ethnicity or race or where they're from, you deserve the death penalty. And it goes, if we flip the coin, it goes the other way, regardless of your race, ethnicity, or where you're from. If you kill one of our children, you deserve the death penalty. And we should make that very clear and send a message across the board. The killing of our children will not be tolerated. And as a Christian, that's hard for me to say, but let God forgive you, because I can't. That is, the slaughter of the innocents is the absolute worst crime that can be committed. Our most vulnerable community. It's terrifying and it's sad that we don't have this already in place. And it was hard for me to explain to Mr. Gonzalez that death penalty wasn't on the table. For a man that had no mercy on his daughter, why are we having mercy on monsters? Give them the same mercy that they gave their crime victims.
April, when I heard about the lack of the death penalty for in Jocelyn's case, I asked the same question. And I was, quite frankly, very surprised that we had not extended that to at least 15-year-olds as a way to try to deter this in the future, that maybe if Texas is well understood, that if you kill innocents in Texas, it's the one place where you'll probably get the death penalty, and then you'll be staring down a jury that will probably back that up. Because that's really the legacy of both these cases, is that Jocelyn and Maria's death not be in vain, that there is a deterrence in the future. And if we save just one child because of this, then, then that's my decision as a Catholic to say, I'm going to file this bill because I'm going to be gone long before you all are. But you are going to be able to carry this message and hopefully prevent the death of a Jocelyn or Maria or of young men and women that have just walked into the Capitol, because I saw a whole busload that just came in this morning. And that's what we're fighting for. Thank you for your testimony.
Thank you.
Thank you.
Thank you all for being here. Members, any more questions? Thank you, Senator Bedford.
Thank you so much.
Bill
Thank you
forward.
for your time.
Good. So Senator Miles present. Thank you, Senator Miles. So seeing no other invited witnesses on this bill, invited testimony is closed. The chair now opens public testimony. The chair calls the following witnesses: Andy Kahn, welcome.
Good morning. Thank you, Chairman. My name is Andy Kahn. I'm the Director of Victim Services for Crime Stoppers of Houston. I've been a victim advocate for over 30 some odd years. I serve on the Board of Parents of Murdered Children and surviving family members of homicide. Like you already heard from April and Alexis, I'm going to tell you another story, a little bit of another young girl named Audrey Cunningham. Audrey Cunningham was 11 years old. She was a fifth grader from Livingston, Texas, and she disappeared February 15th, 2024, while walking to a school bus stop. After a 5-day search, her body was found tied to a rock in the Trinity River, about 10 miles from her home. Suspect was later taken into custody and charged with murder. Originally, he was not charged with capital murder because at that time they could not make a conclusive evidence that there was a sexual assault or any other kidnapping or anything like that. The point of this is you have, for whatever reason, a plethora, and particularly of young girls between the ages of 10 and 15 that are being systematically murdered in the state of Texas. And the perpetrator under current statute is not eligible for the maximum punishment, which is the death penalty. Now, if Audrey Cunningham was 9 years old, or she was 16 years old, then the district attorney would have the discretion of seeking the death penalty. But because Audrey Cunningham is 11, Jocelyn was 12, Maria Gonzalez, 11, same situation. I don't know how we came to this, whatever conclusion, that if you're between 10 and 15, you weren't eligible for the death penalty, but if you're up to the ages of 9 and over 15, you were. I was actually part of the bill in 1993, I'm obviously aging myself, that actually gave capital murder for those who murder a child under the ages of 6. I'll finish up very quickly if you don't mind on
I
this.
don't mind, the chair will extend it.
All we're asking for is the same punishment should be applicable to any defendant who murders a child regardless of the age. It's equal opportunity, and we're asking you to remedy what is obviously a glitch in our statute right now. And on behalf of the children of the state of Texas, on behalf of parents of murdered children and surviving family members of homicide, we would deeply appreciate that this vote get out of committee, get to the Senate, and get to the House, and let's rectify this glitch in the system. Thank you.
Thank you. For any questions, members? Senator Bettencourt.
Just, Andy, there's this lack of you call it a glitch in the system. You know, it's obviously not based upon any crime stats, any facts. It's just simply a gap that we have in the system for 10 to 15-year-olds that needs to be fixed and as soon as possible, right?
Exactly. I mean, I don't know where we came up with this age range, but for whatever reason, it's there. And so now we have, clear-cut examples of why it shouldn't be there. So, and again, these are just 3 cases you heard today. Trust me, there are many, many more that I could delve into, but I think these 3 kind of typify why we need this. And the important thing, again, is it's not a mandate. It simply gives the district attorney the discretion. Right now, they don't have discretion if you murder a child between the ages of 10 and 15 and you don't have another compounding offense such as sexual assault, kidnapping, or robbery. Just let the district attorney's office make that decision whether they want to pursue the death penalty or not. Right now, they can't.
And then, Andy, it's really up to the jury at that point as well.
12 members of the, as I like to say, 12 people in the community ultimately make that call.
Thank you.
You bet.
Thank you, Andy. So seeing no other witnesses on this bill, or does anybody want to testify on, for, or against Senate Bill 990? Hearing none, public testimony is closed. We have a quorum. So Senator Bettencourt moves that Senate Bill 990. Senator Hagenbu?
Just as I listen to this, it was really hard to listen to testimony. I'm so sorry for you. Thank you for the courage of coming to testify today. And, as a Christian, Senator Bettencourt, I feel the same way. I believe life starts at conception and ends at natural death. So this is difficult. But in Texas, we have this law for up to 10 years old, right? And then, as the last witness said, after 16, it doesn't make sense. It's from a logic perspective, we either eliminate it or we fill this gap. And for that reason, and then just after listening to testimony, it's very compelling. I'm in favor of this bill.
Show Senator Huffman is present. Yes, I'm present. Sorry, I was late. Oh, no, that's quite all right. So Senator Hagenbu moves that Senate Bill 990 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
5 ayes.
There'll be 5 ayes and 0 nays. Senate Bill 990 will be reported to the full Senate with a favorable recommendation.
Thank you, Mr. Chairman, members.
Mr. Chairman. Sidebar. Did anyone sign up against this bill? Testify against the bill? Do we have any testimony against the bill? Not a one.
Just one public testimony. And one.
Well, but none of them. Thank you. Just wondering.
The chair lays out Senate Bill 955 and recognizes Senator Huffman. Excuse me. 958. Well, explain the bill.
Yes.
Senator Huffman.
And it's my pleasure to lay out this bill for Senator Parker this morning. Members, survivors of human trafficking often face significant barriers to recovery and reintegration into society, including difficulty finding employment, housing, and other resources due to their criminal records resulting from actions they were forced to take by the traffickers. Non-disclosure of these criminal records can help survivors move forward in their lives, which is why SB 958 is such a crucial piece of legislation. This program allows survivors to shield their criminal records from potential landlords or jobs, but still allows law enforcement to access those records should they need them in the future. This allows survivors to rebuild their lives while still allowing law enforcement access to necessary public safety information. Currently, the records of trafficking survivors can only be sealed of misdemeanor theft, prostitution, and marijuana offenses, but SB 958 aims to expand the list of sealable offenses to include all misdemeanor offenses of drug, forgery of government documents, and public intoxication. Why is this necessary? Because these are offenses that are commonly used by traffickers to coerce and control their victims. For example, traffickers commonly force their victims to use narcotics like methamphetamine and heroin to keep their victims attached to their traffickers as suppliers. Also keeps the victims from going to the police for help and fear of retribution. Public intoxication goes hand in hand with this issue. Traffickers also commonly force their victims to make false identifying government documents to evade capture and allow for easier movement of victims. By allowing survivors to seal these offenses that were committed as victims of trafficking, Senate Bill 958 provides a significant tool to support survivors in their recovery and help them move on from their past experiences. It's important to note that non-disclosure of criminal records can also help combat stigma and discrimination against survivors, which can further contribute to their challenges in finding employment, housing, and other resources. A final note that the intention of SB 958 does not in any way alter the current process for survivors to seal their records. They will still have to go through the exact same process as they do now to convince a court that the crime on their record occurred as a result of their being a victim of trafficking. This is clarified in its thing. He has a committee. Yeah, so a Senate committee substitute for Senator Parker.
Chair recognizes our committee substitute for Senate Bill 958, and Senator Hagenbuth offers it up. Any objections? Hearing none, substitute is accepted.
The committee substitute eliminates a drafting error that expanded the program to crimes committed in connection with being a victim rather than directly as a result of being a victim of trafficking, an expansion that was never intended. Senator Parker and myself urge your support of the committee substitute of Senate Bill 958 to provide critical support for survivors of human trafficking. And I believe he has 2 invited witnesses.
Thank you, members. Are there any questions? Any questions? The chair now opens invited testimony, committee substitute Senate Bill 958. The chair calls Joseph Scaramucci and Andrea Sparks.
Thank you, ma'am. Welcome, my pleasure. I'm sure he'll have to if I get crazy later. Thank you.
Good morning, Chairman, members of the committee. Thank you for the opportunity to speak to you today. My name is Joseph Scaramucci. I'm currently the Director of Law Enforcement Training and Operations at SGS Incorporated. We're a counter-sex trafficking nonprofit. I currently maintain law enforcement credentials, and in 2023, I retired from the McLennan County Sheriff's Office in Waco. In 2014, I helped create our human trafficking unit, which has been recognized both nationally and internationally. Further, I contract as a liaison for federally funded task forces to assist with training and technical assistance for pretty much every major task force throughout the United States as well as internationally. I've been blessed to have the ability to arrest traffickers and exploiters and help provide paths to freedom for their survivors in every corner of the country and around the world. I'm here to express my strong support for Senate Bill 958. For years, I've worked firsthand with victims of human trafficking and exploitation. These are children and adults who were coerced into criminal activities against their will. The trauma these victims endure is unimaginable, and yet, even after escaping their captors, they continue to be punished by a criminal record that follows them for life. I've seen the harms that victims of human trafficking face as a result of their forced criminality. A criminal record denies them access to safe housing, stable job opportunities, and the economic empowerment they need to truly rebuild their lives. Many survivors find themselves unable to rent an apartment, secure meaningful employment, or even open a bank account, all because of the weight they carry from the crimes they were forced to commit. As a result of these records, some survivors are even unable to invest in their own children's lives through school functions or even the ability to join programs such as the PTA. Without a path to clearing their records, they're left vulnerable to homelessness, financial insecurity, and even worse, re-exploitation. Senate Bill 958 assists with a pathway to justice. It acknowledges that many trafficking victims are forced to commit crimes under threats, violence, or manipulation. This bill allows them to petition for an order of non-disclosure, giving them the opportunity to rebuild their lives without the permanent stigma of publicly available criminal records. I want to stress this is not about erasing accountability. It is about recognizing reality. It's about giving survivors a second chance, one that they never would have had while trapped in their cycle of exploitation. Without this legislation, we risk keeping victims in the shadows, unable to access the most basic tools necessary to heal and to reintegrate into society. As someone who spent decades fighting these crimes, I urge you to pass Senate Bill 958. It is necessary in providing true justice for survivors and ensuring that laws punish traffickers and not their victims. Thank you.
Please.
Good morning. Good morning, Chair. Good morning, Senators. My name is Andrea Sparks, and I'm testifying in favor of Senate Bill 958. I'm here on behalf of a new nonprofit I co-founded called Not on Our Watch Texas. Not on Our Watch Texas is an initiative of Texas Women in Business, and our mission is to inspire women in business to educate themselves and others on protecting children from online exploitation, grooming, enticement, and sextortion. I'm also here as a former director of the governor's child sex trafficking team and the former director of the National Center for Missing and Exploited Children's Texas Regional Office. Not on Our Watch supports this bill because we have seen time and time again, as survivors are charged for crimes they were forced to commit by their traffickers, they are further harmed by the very justice system meant to protect them. Ironically, traffickers understand how this works very well, and they use our justice system to keep victims in their grasp. They know that a criminal record can be the thing that makes breaking free from trafficking even harder because it blocks survivors from attaining living wage employment, housing, and educational opportunities they need to be free. And it reinforces what the traffickers tell their victims, that they are unworthy of freedom, that they are to blame for their own victimization, and that they are worthy only of shame and further forced labor or sexual exploitation. They have no option except to continue being trafficked. Senate Bill 958 starts to chip away at this tool used by traffickers by expanding the list of misdemeanors beyond theft, prostitution, and marijuana offenses that can be part of orders of nondisclosure to a victim of trafficking. These include things like possession of marijuana or other substances. Traffickers can force victims to hold drugs, and often do. Public intoxication, traffickers often force victims to consume drugs or alcohol. Disorderly conduct, where traffickers can start a physical altercation or a scene and then blame the victim so that they're arrested. Traffic violations, forcing a victim to run a red light, drive under the influence. Bail jumping, traffickers bail their victims out and then move them to a new jurisdiction. Criminal trespass, resisting arrest, online impersonation, perjury, and so on and so on and so on. And I did consult with a survivor, a friend of mine, who runs a home for women who are coming out of trafficking, and she gave me a long list of these kinds of misdemeanors that she's seen women be charged with because of their victimization of trafficking. So Not on Our Watch wholeheartedly supports Senate Bill 958 because it takes away an important tool that traffickers use to trap their victims in a life of exploitation and abuse, and it gives survivors a fairer shot at escape and healing. Thank you.
Any questions, members? Thank you all for being here. We appreciate it. Are there any additional invited witnesses? Seeing none, invited testimony. This bill is now closed. The chair now opens public testimony. The chair calls the following witnesses: Susie Kennan and Stephanie Holdren. You come forward. Okay, so they're not present to testify. Calling once, calling twice, but they're not. Bill's in good shape apparently. Yeah, Bill's in good shape. Okay. Is there anyone present that wishes to testify on, for, or against committee substitute for Senate Bill 958? Hearing none, public testimony is closed. And the commission substitute is adopted. The chair moves that Senate Bill 958 do not pass, but that the committee substitute for Senate Bill 958 be adopted in lieu of, do pass, and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu.
Aye.
6 ayes.
There be 6 ayes and 0 nays. The committee substitute for Senate Bill 958 is reported favorably to the full Senate. And Senator Heather Hagenbooth moves that the bill also be recommended for local and uncontested. And Senator King present as well. Could you show Senator King is present? Recommended to local and uncontested. Hearing no opposition, it's granted. But next. Oh, yeah, we're gonna go. The chair lays out Senate Bill 487 and recognizes Senator Alvarado to explain her bill. Welcome. Please proceed. Got it. All right, you're in business.
Okay, there we go. Good morning, Mr. Chairman and members. Thank you for the opportunity to lay out Senate Bill 487, which would allow victims of certain crimes to qualify for pseudonyms. Pseudonyms are important to promote public safety in our community because they help victims feel more comfortable to report crime, cooperate with criminal investigations, and participate in criminal prosecutions. Under current law, vulnerable victims of sexual offenses and crimes involving children or trafficking are eligible for pseudonyms. However, it does not cover victims of invasive visual recording or indecent assault. Senate Bill 487 expands the list of offenses where a victim can qualify for a pseudonym to include indecent assault and invasive visual recording. These offenses require victims to provide incredibly intimate testimony and evidence. This bill will protect victims who do not want their names associated with intimate footage or testimony in public records for the rest of their lives. Thank you.
Members have any questions? Any questions? Any invited testimony? Invited testimony on Senate Bill 487 is now open. Is there any? So we have Stephanie Garakanian, but it's not, you wish to testify invited, or just here as a resource? Okay. Well, being no other invited testimony, the invited testimony is now closed. Open it for public testimony. Is there anyone present that wishes to testify on, for, or against Senate Bill 487? Hearing none, public testimony is closed. So, Senate Bill 487, I move the Senate Bill 487 be reported to the full Senate, be recommendation do pass favorably, and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
Aye.
6 ayes.
There be 6 ayes and no nays. Senate Bill 487 be reported to the full Senate with a favorable recommendation. Do you wish it to go recommended for local? So Senator Hinojosa moves that Senate Bill 487 be recommended to local and uncontested calendar. Is there any opposition? Hearing none, so granted. Which one next? Chair lays out Senate Bill 988 and recognizes Senator Betancourt to explain his bill.
Thank you, Mr. Chairman and members. This bill was brought to me by the Dallas District Attorney's Office last session. It's a refile Senate Bill 467 that passed unanimously out of the committee and the floor, but was unfortunately did make it into law. Since the fall of 2021, organized criminal groups have been actually taught how to disrupt fuel dispenser pulsers at gas pumps across Texas. The pulser controls communication between the gas pump and the terminal, which regulates fuel flow at the pump. Criminals are breaking into gas pumps and damaging the pulser to gain unlimited access to fuel, causing substantial financial loss. The suspect will disrupt the pulser. Other suspects then will pump stolen fuel into large auxiliary tanks. We've seen pictures of tanker trucks being hauled off full from various locations. And while the pulser itself costs a few $100s to replace, however, the cost of the theft is 5 to sometimes 6 figures of lost fuel product. Therefore, police officers who catch the suspects are only able to charge them with misdemeanor criminal theft. What happens after the implementation of 988 would amend the criminal mischief statute to clearly provide that damage to destruction of retail motor pump is a third-degree felony. By increasing the penalty for damaging or destroying a motor fuel pump, law enforcement and prosecutors will have another tool to deter this type of organized criminal activity. With that, Mr. Chairman, I'd be happy to answer any questions. We do have an invited witness, which is Steve Fawcett from Dallas District Attorney's Office, Chief of the Gang Unit.
Members, are there any questions? Chair now opens for invited testimony on Senate Bill 988, and the chair calls Steve Fawcett. Please proceed.
Thank you,
You might move the microphone so we can hear you. Thank you.
Thank you, Chairman Flores, and thank you all, chair members, and thank you, Senator Betancourt, for filing this needed piece of legislation. I'm here, again, on behalf of the Criminal District Attorney John Crusoe of the Dallas County District Attorney's Office. I've been a prosecutor for 9 years, previously with the Specialized Crime Division. As of a few weeks ago, I got promoted with our Gang Division. And yes, we have had an influx of organized crime throughout not just Dallas County, but really the entire state of Texas and the United States as a whole. And it's very lucrative to break into gas pumps and steal lots of fuel. A lot of these criminal groups will also break into ATMs to damage the ATMs and to steal the money from ATMs. In prior legislative sessions, we dealt with this exact problem of what do you do when you catch them in the act? They haven't stolen anything yet, but they've damaged the pump, or previously they damaged the ATM. And the bank employee caught them, or the law enforcement caught them. And just like with ATMs, it used to just be a Class C, maybe a Class B misdemeanor, because you caught them in the act. They haven't gotten away with it yet. Well, prior legislative session said, regardless of the pecuniary loss to that ATM, it's a third-degree felony. We know what you were about to do. You shouldn't just be able to walk out of here just because you only caused $50 worth of damage. And that's the same logic that this bill that Senator Betancourt has filed brings to the table. If you damage a motor fuel pump because you're trying to put a skimming device on it to steal people's credit cards, or you're trying to manipulate that pulsar device to steal thousands of gallons of fuel, but you happen to be interrupted in the act, you shouldn't just be able to walk away. And I personally have had patrol officers call me in that exact same scenario. We caught them. They busted into the pump. Well, how much damage did they cause? Well, they cut a $2 bolt and, okay, so Class C misdemeanor, here's your ticket. Well, we're asking that become a third-degree felony so that we can bring them to justice, just like we have with ATMs. And with that, I ask for your full support of Senate Bill 988, and I will answer any questions that anyone has.
Well, thank you for taking the time to be here. Any questions? Any questions?
Senator
Betancourt?
Thank you. Thank you for restating the obvious, because once you catch them and they haven't actually done anything, their intention is clearly obvious. The average criminal, even the average criminal, doesn't run with a pulsar, a disruptor. And when they're doing it, their next intention is to load up a tanker truck and steal, tens of thousands of dollars of fuel next, right?
They'll steal as much as they can get away with. And it's if you know what you're doing, it's actually very easy. In fact, in the packet that we provided, if you go to page 4, you can buy these devices on Amazon for $250 that allow you to.
Oh, they've got an EMS, they've got a pulsar?
That particular one's a skimming device, but also tampering with the pump. But they've gotten pretty brazen. They're not just homemade anymore. Now you can buy it online. And we're working on that. There's some ongoing investigations into the people selling these devices. But that just tells you how brazen they are out there if they feel like they can go online and sell them on eBay.
Well, that's not necessarily the technology process that I want to see after 2 years, but if we need to add anything to the bill, maybe an amendment on the floor. I guess I'm never shocked anymore. I may be surprised by what I hear in testimony, but it's nice to know that somebody's selling a pulsar disruptor on Amazon, because there's only one use for it.
Yeah, there's no legitimate purpose for disrupting. And if you don't know what all it is it says your fuel meter's at a certain amount. It's just a little wheel that spins in the pump. So if it's $3 a gallon, it spins at a certain rate. It just slows it down, so it's like a penny a gallon.
Right, a penny a gallon. So
they use a gift card or a stolen credit card, and then next thing you know, the gas station's emptied.
And this started in Dallas, Steve. But it's now metastasized all across the state.
I wouldn't say it started in Dallas.
Okay.
But it has certainly been very prevalent in Dallas. But it is absolutely across the entire state.
Well, I would never blame Big D for anything with criminal behavior. Thank you, Mr. Chairman.
Any questions? Any questions, members? Thank you very much for being here.
Thank you for your time.
So seeing no other invited testimony for this bill, the chair now closes invited testimony. Chair now opens public testimony. The chair calls the following witness, Charlotte Medler. Charlotte Medler. Thank you for being here. Identify yourself for the record.
Thank you. My name is Charlotte Melder. Sorry about the
Your position.
I'm actually here as a resource witness for the Texas Department of Licensing and Regulation. I don't have provided testimony, but I'm happy to answer any questions you may have.
Any questions, members? Thank you. There's no
Thank you.
questions. Is there anyone present that wants to testify on, for, or against Senate Bill 988? If not, public hearing is closed. Senator Hinojosa moves that Senate Bill 988 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman. Senator Miles. Senator King. Senator Hagenbu. 5 ayes.
There be 5 ayes and no nays. Senate Bill 988 be reported to the full Senate with a favorable recommendation. Do you want to go to the floor with it, or local? Senator Huffman recommends Senate Bill 988 be recommended local and uncontested. Is there any opposition? Hearing none, so granted. Thank you. Chair now calls up Senate Bill 535 and recognizes Senator Huffman. And Senator Huffman offers a committee substitute for Senate Bill 535.
Thank you, Mr. Chairman, members. I do send up the committee substitute.
Senator Huffman offers a committee substitute for Senate Bill 535. Senator Hinojosa asks that it be considered for a substitute. Is there any opposition? Hearing none, so ordered.
Thank you, members. Texas's Rape Shield Law, Rule of Evidence 412, protects victims of sexual assault and aggravated sexual assault by generally excluding evidence of their past sexual behavior or reputation. However, this rule does not extend these protections to victims of human trafficking or child-specific sex crimes, such as continuous sexual abuse and indecency. The committee substitute to Senate Bill 535 aims to address this gap by expanding Texas's Rape Shield Law to include all major sex crimes, not just sexual assault and aggravated sexual assault. The expanded coverage includes trafficking of persons, continuous sexual abuse of a young child or disabled individual, and indecency with a child. The committee substitute clarifies that reputation and opinion evidence is always inadmissible. However, specific instances of a victim's past sexual behavior may be admissible in cases where lack of consent is an element of the offense. The committee substitute to Senate Bill 535 ensures that victims of trafficking and child-specific sexual offenses receive the same legal protections regarding the admissibility of evidence about their past sexual behavior as victims of sexual assault and aggravated sexual assault.
Members, any questions? If not, the chair now opens for invited testimony on committee substitute. Senate Bill 535 is now open. The chair calls Julie Schaefer. Kaylee Schaefer. And Elisha Bird.
Good morning, Chair Flores. Thank you for allowing us to be here today. Committee, thank you. And Senator Huffman, thank you for your support. My name is Julie Schaefer. I come to you as a parent. This is a role I take very seriously, parenting. It is a hard role, as we all know, especially with girls. I've done it twice now with girls. It's a roller coaster ride, but our roller coaster hit a low in December of 2020 when my husband and I realized and were made aware that our daughter had received several rounds of trauma. And we were not aware of that. It was a surprise to us. So my first question to myself as a parent was, how did I not see this? And immediately then, how can I protect her?
According to a study conducted in 2013, it is estimated that 62% of teens have been exposed to at least one traumatic experience. Our daughter was now a statistic. As we all know, there are other statistics that come with such trauma, and that includes risky behavior. We were not sheltered from that. We worked to protect her from harm to herself, but unfortunately, some of the coping from the trauma was just that. As a family, we waited 3 long years, with her feeling uncared for by the justice system. 3 years trying to convince her that justice would be served. That turned into her social media accounts being used to expose a trauma-filled girl. One thing that the social media didn't show is what she was dealing with at home, behind closed doors. The feeling of loss of family due to the events, the feeling of not being supported. One was the act of after the trauma occurred, that wasn't made evident. The acts were after the trauma. That's an important part of this, I believe. Please know I'm not here to give permission for all of her actions. I'm here to plead with you in understanding there are far better avenues that could be taken than trying to find dirt on a minor through social media to justify a crime against them. Her choices do not define who she was then nor who she is now. And I think we all are glad that that's the case. I know I am. Thank you for letting us be here today.
Thank you for being here.
If I could
Senator
ask a
Huff.
question. Thank you for being here and for sharing your daughter's story. And yes, her behavior is quite typical of young people who are sexually assaulted. I think all the experts in the room would agree with that. You mentioned that there was a 3-year delay, and I'd like to follow up on that. Was that police office, investigation slow, people didn't take your report seriously, or was it the court system, or all of the above?
You want me to answer that?
I ask because I want to talk about if we're failing.
Sure, sure. There just continued to be setbacks or an attorney needing more time.
Okay.
And
the
to
court
be
system?
honest, it was to dig up the social media.
Okay.
Yeah.
So it was in courts, but it was delayed in courts. Is that correct? Yeah.
Yes.
Senator, I may be able to answer that question
Yeah.
a little bit better.
Can she answer the question?
Yes.
Chairman,
If-
if you would
Identify
Yes.
yourself
Yeah.
for the record.
My name is Alicia Bird. I am the First Assistant District Attorney for the 35th Judicial District Attorney.
Yeah.
I was one of the prosecutors involved. I was not the lead prosecutor on the case. But certainly that is something that we commonly see is delay of a case so that there is time and opportunity to obtain information about victims that can then be used, even though those actions may have occurred after the crime was committed.
So do you think this bill would help protect against that in some ways because it's not going to be admissible anyway?
Absolutely,
Yeah.
absolutely. The specific relevance that is required under this bill for sexual activities of minors to be admissible means that only if there's some relevance to the trial at hand would a defense attorney be able to go into those specific sexual acts.
Right. Okay, thank you. Thank you, Mr. Chairman.
Thank you.
Thank you. Thank you for allowing me to be here. It's on my phone, so if I'm looking at it, this law is important to me because I fought a sexual assault case as a minor against an adult for 3 years. We would go back and forth between taking a plea or going to trial. I was scared to go to trial by the end of it. I was 14 when it happened and 17 by the time it ended. 3 years is a lot of time for someone to make mistakes, and that's what I did. I started hanging out with the wrong people. I was going out to parties. I was doing things I shouldn't have been doing. And everything I did was going to be used against me. I don't think that it's fair for something to drag out that long and the victims be the ones who have to deal with their consequences of their choices years later. I was scared to go to trial because of my past and the mistakes I had made, but those mistakes do not mean my trauma wasn't real. Yes, I was doing things I shouldn't have been, but the root to that problem was what happened to me. No minor should have to sit in a courtroom full of adults and discuss sexual history, especially when it has nothing to do with the assault.
If you can just identify yourself for the record, please.
Kaylee Schaefer.
Thank you.
Thank you for allowing me to come as well. As I said, my name is Alicia Bird, and we are here because of working on this case with Kaylee. She is the person who startled us into realizing that there is a loophole in our current rape shield law. My co-counsel sitting on the trial with me came to me one day, and as a younger and less wise prosecutor, I gave her a pat answer that I thought was right. I told her, don't worry, you can tell this beautiful young lady that they can't go into all the things that, the bad decisions that she's made since she was molested. I didn't realize that the law actually only covers sexual assault charges and aggravated sexual assault charges. The situation in Kaylee's case was an indecency with a child, and so she was not protected. And through the process of having those meetings with her during those 3 years and having to say, we are going to have to get you ready for a criminal trial in which you can be asked about every sexual activity that you have engaged in since this occurred to you and before, of any nature. There's no limits currently in the rules of evidence. That was heartbreaking and drove our office to the point where we wanted to come ask you to pass this bill. We are closing several loopholes that involve children, indecency with a child, continuous sexual abuse of children, and trafficking of persons. Those three offenses in particular, it is so common to hear defense attorneys come in and tell us that our victim is, and these are actual words used in a courtroom, our victim is a slut, or our victim has done things that they don't want us to talk about in the courtroom. And so in Kaylee's case, we actually did wind up reducing the case down as a result of how difficult it would be to go to trial and to face that prospect. And we would like to be able to work towards a world in which, as prosecutors, we can sit with victims and tell them, look, you don't have to talk about every sexual activity you've ever had in your life. You only have to talk about this offense and anything that may directly relate to this offense as determined by an impartial judge. And so we ask you to help us close this loophole and protect these victims in these circumstances so that we can get better justice.
Thank you, Senator Miles.
Thank you, Mr. Chairman. Kaylee, I want you to know that you're doing something fantastic here, okay? And we thank you for coming forward, because by you coming up, you're going to be able to save thousands and thousands and thousands of young ladies coming behind you. And remember this, it's not how you start, it's how you finish. Take care.
Thank you.
Thank you.
Senator Huffman, you have a question?
Oh, no.
Thank you all for being here. Thank you for your testimony. Are there any additional invited witnesses? Seeing none, invited testimony's bill is now closed. The chair now opens public testimony. And we have no one signed up for public testimony. If there's anyone on for or against this bill, if you will come forward. If not, public testimony is closed. So we have adopted committee substitute for Senate Bill 535. Being that there was no objection, the committee substitute is adopted, and the chair moves that committee substitute for Senate Bill 535 do not pass, that Senate Bill 535 do not pass, but that the committee substitute for Senate Bill 535 be adopted in lieu of do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes.
5 ayes and no nays. The committee substitute for Senate Bill 535 is reported favorably to the full Senate.
Take that to the floor so we can shine some light on the issue.
We will take it to the floor. Thank you very much. Chair lays out Senate Bill 1019 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, the Human Trafficking Omnibus Bill from the 88th Legislature raised the age limit for alleged child victims to receive support from an outcry witness in criminal proceedings involving sexual assault and trafficking offenses, increasing it from a child younger than 14 to a child younger than 18. However, this change to the Code of Criminal Procedure was not accompanied by a corresponding update to the Texas Family Code. As a result, in sexual assault and trafficking cases handled in juvenile court, an alleged victim may only be supported by an outcry witness if they are 12 years old or younger. Senate Bill 1019 addresses this discrepancy and really an oversight in hearsay statement admissibility between criminal and juvenile proceedings by raising the age limit for an alleged victim to receive support from an outcry witness in juvenile cases from 12 or younger to 18 or younger. Additionally, to ensure consistency across legal codes, the bill explicitly defines person with a disability by referencing Section 2204 of the Penal Code, aligning the definition with disabled individual. Overall, Senate Bill 1019 enhances protections for vulnerable individuals by standardizing the admissibility of hearsay statements across legal proceedings and clarifies the definition of a person with a disability across legal codes. Bill.
Members, are any questions? So with that, invited testimony on Senate Bill 1019 is now open. The chair calls Michael O'Brien. You proceed.
Thank you very much, and thank you, Chairman Flores and esteemed members of this committee. My name is Michael O'Brien, and I am the Chief Prosecutor in Dallas County of the Juvenile Division, and I am here in support of my boss, Dallas Criminal District Attorney John Creuzot. I would like to extend my deepest gratitude to Senator Huffman for identifying this disconnect between adult and juvenile prosecution that causes our system, the juvenile system, to treat sexual assault victims of juvenile perpetrators differently. Senate Bill 1019 addresses a critical gap in the law relating to the sexual offenses prosecuted in the juvenile courts. This bill conforms the Family Code to allow for outcry witnesses to be utilized in juvenile court when our victims are 18 and younger, mirroring the Code of Criminal Procedure you have updated over the last few sessions. Specifically, it raises the age for the outcry witness hearsay exception in juvenile court, bringing it in line with the adult law where the age limit has been raised over the last two sessions to 18. Currently, this provision is only available to our victims who are 12 years of age or younger. Senate Bill 1019 protects our victims between 13 and 18 by allowing critical support when their personal experiences must be discussed in a courtroom in front of strangers, which is often difficult for young victims to provide, especially when reliving traumatic experiences and events. This bill ensures these victims in this age group, will have the same opportunity to have an outcry witness testify in court, just as the adult system provides. This bill does not alter the juvenile process. It only enhances it by giving victims an equal and stronger voice and ensuring their trauma is not compounded by a restricted legal framework. I'd like to share a recent case in my courthouse that underscores the urgent need for this to change. This month, we have a sexual assault case scheduled for trial, and it involves a 15-year-old victim who made an outcry to her mother after being sexually assaulted. Due to the current juvenile law, there will be no outcry witness testimony, as the Juvenile Justice Code has not been updated to reflect the adult law. The entire story of the victim's outcry, often one of the most powerful pieces of evidence that comes, and I apologize, of evidence in any abuse case will be left untold in the courtroom. Her mother will never have an opportunity to share intimate details her daughter told her as an outcry witness. Had the perpetrator been an adult, the victim's mother would be able to testify about those intimate details and the story would be heard. In juvenile court, under the current law, that essential testimony is silenced. This is not just a legal technicality. It's a failure to provide justice and support for the vulnerable young victim. This bill is about creating fairness and equity in our legal system, ensuring that victims of juvenile offenders have the same opportunity to have their voices heard as those in the adult system. I ask for your support in passing Senate Bill 1019 so we can better serve and protect our children and give them the justice they deserve. Thank you very much for your time.
Thank you. Senator Hinojosa.
I guess under present law, that type of testimony will not be allowed based on hearsay.
Correct. In other words, the mother would be able to testify, but not as any kind of exceptions through the hearsay exception of witness hearsay that way.
Even though it's really an outcry.
Correct.
Thank you.
Any questions? Thank you. Thank you for
very
being
much.
here.
Thank you.
So seeing no other invited witnesses on this bill, invited testimony is now closed. The chair now opens public testimony. And I see that there are no one wishing to testify on, for, or against Senate Bill 1019. Public testimony is closed. Senator Huffman moves that Senate Bill 1019 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker, Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles, Senator King, Senator Hagenbu. 5 ayes.
There be 5 ayes and no nays. Senate Bill 1019 be reported to the full Senate with a favorable recommendation. Senator Miles moves that Senate Bill 1019 be recommended for local and uncontested. Any opposition? Hearing none, so granted. Chair lays out Senate Bill 1021 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Stalking is a serious offense that can escalate into more violent behaviors and have long-lasting psychological impacts on victims. Under current law, individuals convicted of stalking may still be eligible for community supervision, which can leave victims vulnerable to continued threats and intimidation. Senate Bill 1021 seeks to prioritize victim safety by making defendants convicted of stalking ineligible for community supervision. Additionally, the bill authorized the Department of State Health Services to suspend, revoke, or deny emergency medical service or EMS certifications or licenses if personnel, providers, or their affiliates have stalking-related convictions or deferred adjudications. These measures prioritize victims and enhance safety within essential healthcare services. And members, I will say that, stalking, since social media has taken over the world and just digital communication, stalking is much more, I think, pronounced, and we see more of it because of that. So that's why I think they have a need for this legislation. Thank you.
Thank you. Members, do you have any questions? So we have invited testimony. Senate Bill 1021 is now open. The chair calls Rachel Burris. Thank you. If you state your name and
Good morning.
proceed.
Rachel Burris. Thank you, Chairman Flores, Senator Huffman, and members of the committee. My name is Rachel Burris, and I am representing my boss, Dallas Criminal District Attorney John Creuzot, in support of Senate Bill 1021. I have 20 years as a prosecutor and am currently a felony court chief. I have handled every type of criminal case and have seen the real positive effects of designated a case ineligible for probation and its role in parole eligibility. Senate Bill 1021 adds stalking to the list of cases that are ineligible for probation from a judge. People who commit the offense of stalking rarely stop stalking their victims without criminal intervention. According to the Stalking Prevention Awareness and Resource Center, 1 in 3 women and 1 in 5 men have been stalked in their lifetime, and 11% of them have been stalked for more than 5 years. I have seen firsthand the truth in these numbers. The offender that does this behavior for weeks, months, and years on end. Truly, we may never know how long an offender engages in this behavior because too many end with the offender escalating to an assaultive offense. And a short stint in custody isn't going to deter that offender. Right now, the punishment is mathematically less than 2 years for a full sentence, even less if they receive pretrial time credit. And by leaving this case out of the codification of cases that 42A054 applies to, that is exactly what punishment for this offense looks like, shorter than a misdemeanor offense. Senate Bill 1021 prevents these short sentences. To bring home this need in our system, in one particular case my office prosecuted, in 2017, a victim reported the defendant for stalking to law enforcement. His behavior was typical to stalking. Emails, cards, then he showed up at her office and then at her home. He was criminally charged with harassment and stalking, but he did not stop contacting the victim. Indeed, he listed her as his emergency contact to the leg monitoring agency. She pursued and received a protective order. However, he was not deterred. He continued to contact her for over the period of 4 years while this case pended. He sent more and more letters. Eventually, he was convicted and placed on probation. Yet his worrisome behavior did not end. In fact, he cut off his leg monitor while on probation, was subsequently revoked, and he was given the maximum sentence of 10 years, which would place him out of custody in 2031, except his projected release date is in a few months. It's time we protect our stalking victims and send a clear message to perpetrators. Please support Senate Bill 1021. Thank you.
Senator Huffman?
Nope, sorry.
Thank you. Thank you for being here.
Thank you.
So seeing no other invited witnesses on this bill, invited testimony is now closed. Chair now opens public testimony. And we see no one signed up for public testimony on, for, or against Senate Bill 1021. Public testimony is now closed. So Senator King moves that Senate Bill 1021 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes.
There'll be 5 ayes and 0 nays. Senate Bill 1021 will be reported to the full Senate with a favorable recommendation. Senator King moves that Senate Bill 1021 be recommended for local. Any opposition? Hearing none, so granted. Chair calls up Senate Bill 761 and recognizes Senator Hinojosa. Senator Hinojosa, Officer Committee Substitute for Senate Bill 761. Or Senator Miles, would you offer it up? Committee Substitute for Senate Bill 761. Any objection to considering Committee Substitute for Senate Bill 761? Hearing none, so ordered. Recognize Senator Hinojosa to explain his Committee Substitute for Senate Bill 761.
Thank you, Mr. Chairman and members. Senate Bill 761 relates to the rights of crime victims and the enforcement of those rights. Texas has made meaningful and significant strides to ensure that crime victims have rights throughout the criminal justice process and that their safety is prioritized. Violent crime is both a personal and a public safety issue, and by continuing to improve our criminal justice system, we can keep more Texans safe. Senate Bill 761 adds clarity, timeframes, and communication requirements to the Crime Victims Bill of Rights statute. Prosecutors would have to give survivors 5 days notice or notice as soon as possible about any court proceeding, as well as notice that a plea bargain hearing has been set so that the victim can prepare to attend. The victim would be informed early in the criminal case that the state's attorney is not their attorney, alleviating confusion that victims experience and different expectations they may have in the process about the state, the district attorney being their personal lawyer. Texas law already states that victims have the right to assert their rights. This bill simply clarifies that victims may have an attorney assert those rights on their behalf. This would have also imposed a civil and administrative penalty on safe-ready health care facilities that refuse to follow existing and long-standing Texas law by not offering survivors the opportunity to have a trained rape crisis center advocate present during the forensic exam. And the committee substitute Part of the changes in the bill, in the original bill, was the result of negotiations with the prosecutors who had significant concerns with certain provisions of the bill. The committee substituted removed certain sections that dealt with giving the victim rights to sue or ask for an injunction of the court. And I'll be glad to answer any questions.
Any questions, members? If not, we'll move on to invited testimony on committee substitute for Senate Bill 761 is now open. Chair calls Sophia Struther, Samantha McCoy, and Rhonda Kuykendall. Okay, so we have one more. I think she's in. She's not here? Okay, well then we'll proceed, please.
Please excuse my voice. My name is Sophia Strother Lewis. Thank you, Chairman, and all of you that are here. On January 1st, 2021, my world ended. I was tortured, raped, and by all definitions kidnapped, unable to leave until I fought my perpetrator off by a man our system knew, an illegal immigrant from Nigeria who had already been convicted of a federal crime in 2018, a man who should have never had access to me, a man sentenced in a 7-person money laundering scheme that targeted U.S. victims. Augustine Daffy Akulo, residing in Austin, received 97 months in federal prison and was ordered to pay over $800,000 in restitution. However, he was released from federal custody a year later, only to steal something far more precious: my safety, my dignity, my sense of self. On November 16, 2023, he was convicted of raping me in Williamson County. Still, for 65 weeks, this man has been on the run after cutting off his ICE monitor before sentencing. 65 weeks of fear, of constantly looking over my shoulder, waking up gasping for air, knowing that this man who violated me could walk into any room I enter. But the damage didn't stop there. My entire life unraveled in the pursuit of justice. Every piece of my personal information was laid bare in court, stripping away the protection of my pseudonym the moment my trial began. I had to terminate a multi-million-dollar contract with Amazon, forced to choose between my safety and my success. My business, one that once employed hundreds, paid over $2 million in payroll, and contributed to the very fabric of this economy, crumbled under the weight of fear, my health battles from the torture, and intimidation in 2024. I was never given an advocate from the local law enforcement in Williamson County. I was never informed that the prosecution's advocate wasn't fully actually there to support me through the process. The former district attorney of Williamson County told me I didn't need an attorney and that there wasn't a such thing as victims' rights and that the state would protect me. Instead, I was left to navigate this process like so many other survivors, naked, alone, and exposed. Senate Bill 761 is not just words on a paper, it's a lifeline. It's the bare minimum of what survivors deserve: the right to be notified when the plea deal happens before they are signed away in silence, the right to an advocate, someone to stand beside us when we are stripped of everything, when we are forced to relive our worst moments for strangers. 4.5 hours for me on the stand as I had to look at my son, who was also the product of me being trafficked as a juvenile, who will never know the cost of what they are asking of us. The bill is not radical. It is not complicated. It's justice, it's dignity, it's humanity. Because I have already lost too much, don't let another survivor stand here 2 years from now telling my same story. Please pass Senate Bill 761. Thank you.
Thank you. Yes, ma'am.
Good morning, and thank you so much for your time today. My name is Samantha McCoy, and I'm here to testify in strong support of Senate Bill 761. I am before you today not as just as a Texan, but as a survivor of rape, a survivor who has endured firsthand the profound gaps in our justice system. In my junior year of college, I was physically beaten, raped, and a video of the crime was recorded and disseminated to further re-victimize me. Among many of the injustices I faced, one of the most devastating was the absence of an advocate during the medical examination process. After being escorted to the emergency room by law enforcement, I was left in the dark, unaware of what to expect or even that I had the right to an advocate by my side. Instead, as a terrified young adult with no prior experience of even attending a doctor's appointment alone without my parents, I found myself stripped and prodded for evidence. As photographs were taken of my injuries, all I could think about was how desperately I wanted someone there to support me. The absence of an advocate continued during the investigative interviews with law enforcement. The interviews caused untold harms to me. I was disbelieved, mocked, forced to repeat in excruciating detail the trauma of the assault over and over again to multiple officers. Requests for breaks were denied, and at one point I pleaded for my mother's presence just for comfort. This too was denied. Words cannot fully capture how devastating this experience was. If an advocate had been present, they could have ensured I was treated with basic dignity, offering emotional support, facilitating breaks, providing access to resources, and ensuring a fair treatment. Instead, I was left to navigate it alone. Sadly, my story is not unique. Every day, survivors of sexual violence disengage from investigations because of these very gaps, leaving countless perpetrators held unaccountable. The national reporting rate for rape has plummeted from 40% to 25% in recent years, with survivors citing fear, mistrust in the system, and emotional distress as the primary reasons. Senate Bill 761 is a crucial gap towards addressing these gaps. It enforces survivors' rights and ensures that no survivor has to feel abandoned by the very systems that were meant to protect them. Cooperation from victims is essential, and we owe it to those who courageously come forward to treat them with the care and the respect that they so deserve. I urge you to vote in favor of Senate Bill 761. Thank you.
Thank you, members. Any questions?
Yeah, one of the things that has happened throughout the years, it used to be that the prosecutors would be somewhat insensitive to the trauma that the victim has gone through. But over the years have changed, slowly but surely, where we have the district attorneys more involved and more sensitive in understanding that the victim needs to be involved in the process, not only having an opportunity to testify in court in case there's a plea bargain, but also being able to have help, an advocate when they need one. So we're continuing to make progress. I think we're getting a very positive response from different prosecutors throughout the state in making sure that the victims get to participate in the process itself, so they get some feedback of how to handle the case. But thank you both of you for testifying.
Senator Miles.
Mr. Chairman, I want to thank publicly Senator and the host for bringing this bill forward, and say to you ladies, on behalf of, I heard one of you say, the state let you down. Take this opportunity on our behalf to apologize to you both for the letdown. We're not perfect. The system's not perfect, but as you can see, we're up here every 2 years trying to change it and make it perfect. But I would tell you to keep your faith and keep your fight. Thank you.
Thank you, Senator Miles. Thank you all for being here. We appreciate all the time, and again, we're going to work with you to make sure the justice is served. And thank you for being a great part of that process, both of you.
Thank you.
The chair will call Rhonda Kuykendall. Is Rhonda Kuykendall present? Being that there's no members, there's no more invited witnesses. Invited testimony is now closed. The chair now opens a public testimony, and the chair calls following witnesses: Alan Place, and Paula Marks. Thank you, Ms. Marks. We'll start with you. You state your name and your position, and you have 2 minutes.
Yeah, my name is Paula Marks. I'm the Director of Forensic Nursing at the Safe Alliance here in Austin, Texas. And I'm here as a resource for any questions related to this bill.
Members, any questions? If not, Mr. Place.
Mr. Chairman, my name is Alan Place. I'm here on behalf of the Texas Criminal Defense Lawyers Association. I did sign up on the bill. I've had a chance to fully review the substitute. We did have some original questions on the bill as filed, but as the substitute addresses all of our concerns, we'd be in support of the bill.
Thank you. Senator Hinojosa?
Mr. Chairman, Mr. Place used to be the chairman of the Committee of Criminal Jurisprudence on the House side for many years.
Oh.
So he's been up here for many, many years, and as it relates to dealing with the legislative process. So good seeing you again.
Good to see you, Senator.
Any other questions? Thank you all for being here. We appreciate it. Any more? So the chair sees no more folks signed up for public testimony. So anyone that are here to testify on, for, or against the Senate Bill 761? If not, public testimony is closed. So the chair moves that Senate Bill 761 do not pass, but that the committee substitute for Senate Bill 761 be adopted in lieu of their do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker. Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King.
Aye.
Senator Hagenbu. 5 ayes.
There be 5 ayes and 0 nays. The committee substitute for Senate Bill 761 is reported favorably to the full Senate. Senator Miles recommends the committee substitute for Senate Bill 761 be referred to local and uncontested. Is there any objection? Hearing none, so granted. Chair lays out Senate Bill 1120 and recognizes Senator Hinojosa to explain the bill.
Thank you, Mr. Chairman and members. Senate Bill 1120 deals and relates to expanding family violence victims' rights. During the last session, the 88th session, Senate Bill 409 granted victims of sexual assault, stalking, indecent assault, and trafficking the right to confer with prosecutors on disposition decisions, including plea agreements, rather than just solely getting notice of those decisions. However, victims of family violence were not included and do not have the same rights under present law. This measure would build on the groundwork of Senate Bill 409 that was passed last session and ensure family violence victims are afforded the same rights as other victims. The ability to confer would also provide a critical opportunity for the victim to express how a potential agreement could impact their safety. Senate Bill 1120 adds a new section to the Crime Victims' Rights Statute focused on the rights of family violence victims. It gives victims a right to confer with prosecutors on disposition for family violence offenses, including potential plea agreements. It gives victims the right to disclosure of evidence collected during an investigation unless disclosure could interfere with the investigation or prosecution of the offense. It provides that a victim be notified that the prosecutor does not represent the victim. Again, many times there's confusion with the victim thinking that district attorney is their attorney when in fact the district attorney represents the state and not the victim. Senate Bill 1126 to update the Crime Victims Bill of Rights to ensure family violence victims receive the same rights as other crime victims. With that, Mr. Chairman, I'll be glad to answer any questions.
Thank you. Members, are there any questions? Senator Hinojosa, any questions? If not, we'll move on to invited testimony on Senate Bill 1120 is now open. The chair calls Audria Thomas Maltzberger and Staley Heatley.
Hello, thank you for the honor of being here today. My name is Audria Thamez Maltzberger, and I am a survivor of domestic violence at the hands of my former partner. I'm here today to register strong support for SB 1120 related to survivors of family violence having the right to confer on possible plea agreements. Thank you, Chairman Flores and the committee for providing the opportunity to speak today. I am a constituent in Senator Parker's district and would like to thank Senator Hinojosa and Senator Huffman for standing with survivors of domestic violence by authoring this important bill. I'm here today to share the impact that this bill could have had on my life and can have on the lives of many victims of domestic violence. I was in an abusive marriage that lasted for 12 and a half years, and in the end, it took broken bones for me to leave. At the time of his criminal proceedings, I was not given the opportunity to discuss the plea agreement offered to him and was only notified of the outcome after the plea was accepted. The outcome of this plea agreement was a reduction from felony aggravated assault to a mere misdemeanor, along with court-ordered batterers intervention classes. I feel that the lack of communication regarding these charges caused re-traumatization and was yet another act of abuse on his part. I feel that this was a lost opportunity to support my safety and have my voice be heard while sending the message to him that this charge was a serious crime and also hold him accountable for his actions. I believe that SB 1120 would close a major gap in the Crime Victims' Bill of Rights for family violence victims, an important group of victims without the right to confer on a possible plea agreement. The right offered through this bill is not only an important legal right of all survivors should have, but an important part of the criminal justice process that honors the trauma and suffering a victim has endured. Please pass SB 1120 so that survivors of domestic violence have the chance for their voice to be heard. Thank you so much for your time. I strongly support and humbly ask that you vote SB 1120 favorably out of committee. Thank you.
Any questions, members?
Just
Senator Hinojosa.
Thank you, Mr. Chairman. Point out that this is a perfect example of someone being charged with aggravated assault, broken bones, and then without notifying the victim, dropped to a misdemeanor, which really leaves a huge gap there that person go back and recommit the same crime afterwards, and not being at least punished sufficiently for the crime he committed and the violence he committed against the victim. So thank you for testifying.
Thank you.
Thank you. Thank you for being here. No one should have to endure what you had to endure in domestic violence, and thank you for being here, working with us to be able to provide for better protection.
It is an honor. Thank you.
Mr. Farkas.
I just want to thank you again for being here, and I'm sorry we've not met before, but let me know how we can be of service to you, and appreciate you coming forth your story and to be able to save and protect other people's lives. So thank you for what you're doing.
I appreciate that
Thank
so
you.
much. Thank you.
Mr. Heatley.
Good morning, Chairman Flores and members of the committee. My name is Staley Heatley, and I am currently the Wilbarger County Attorney. I have been for the last few months. Prior to that, I was the District Attorney for the same jurisdiction for a period of 18 years. And I'm here to speak in strong support of SB 1120 and want to thank Senator Hinojosa and Senator Huffman for authoring this important legislation. In my almost 20 years as a prosecutor on both the felony and misdemeanor level, I've handled many family violence cases and had the chance to view them from multiple angles. I've handled everything from domestic violence homicide all the way down to a Class A misdemeanor. Part of my work as a prosecutor for the last decade or so has been doing everything I can to help us serve victims of domestic violence in our state and for us to do a better job in law enforcement and prosecution in handling these cases. To that end, I serve currently as the co-chair of the Texas Council on Family Violence Public Policy Committee, and I can state to you that that committee strongly supports this legislation. What this bill does is essentially allow for victims of domestic violence to have the same rights that we already provide to victims of sexual assault, stalking, indecent assault, and human trafficking. It lets those victims have the right to sit down with the prosecutor and discuss the disposition of their case. That should be happening in every single domestic violence case across this state. As both a former DA and now as a county attorney, I've seen firsthand how including a victim's voice enhances justice, strengthens cases, and increases safety for victims. I meet with every victim of a domestic violence case that I have in my jurisdiction, whether it's a felony or a misdemeanor, so that we can be on the same page to make sure that they are safe and that at the end of the day, we have brought them justice and held the offender accountable. SB 1120 simply ensures that victims of family violence have the same rights as other crime victims and that prosecutors are making informed decisions based on the reality of each case. And I would urge the committee to pass SB 1120 favorably and would answer any questions if there are any.
Any questions, Senator Hinojosa? Any questions? Thank you all for being here, being a part of this.
Thank you very much.
So seeing that there are no other invited witnesses on the bill, invited testimony is now closed. Chair now opens public testimony, and the chair calls the following witnesses. We have no one signed up on this bill. Is there anyone on for or against that wishes to testify from the public? If not, hearing none, public testimony is closed. So Senator Parker moves that Senate Bill 1120 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu. 6 ayes.
There be 6 ayes and 0 nays. Senate Bill 1120 be reported to the full Senate with a favorable recommendation. Senator Parker moves that Senate Bill 1120 be referred to local and uncontested calendar. Is there any objection? Hearing none. Granted. Next.
Okay, so you can pass
Let me do mine. We're going to pass the gavel to you. So we'll go to 251. So at this point, I pass the gavel to the Vice Chairman.
The chair lays out SB 251 and recognizes Senator Flores to explain his bill.
Thank you, Mr. Chairman, members of the committee. Courts across the state have been overwhelmed with cases, and slower response to cases creates injustice in the criminal justice system. Enshrined in our Constitution is the right to a fair and speedy trial, and the courts in Bell County need help in fulfilling this constitutional promise. Senate Bill 251 aims to establish criminal law magistrates in Bell County to assist in handling the county's criminal caseload more efficiently. The bill is designed to address the increasing criminal caseload in Bell County by establishing criminal law magistrates. This aims to enhance the efficiency of the judicial process by providing additional judicial resources to handle routine and preliminary matters in criminal cases. The Commissioners Court of Bell County will be granted the authority to appoint magistrates to serve the courts, and they will be able to use their authority to give preference to cases involving individuals held in the county jail. I'd like to thank Judge Blackburn for his work on this bill and for his leadership in Bell County. Committee members, I'm open for any questions on this bill. And we have a resource witness, the Honorable Judge David Blackburn, present.
Senator Huffman.
Yes. Chairman Flores, just a quick question. I know you know I have Senate Bill 664, which was going to raise statewide standards for magistrates. And there is some, for the smaller counties, there is a requirement of just 2 years of law experience. I'm not sure.
I think
Can we work this out?
Yes,
together? Yeah.
Yes, I believe we can, and I think our bills actually go hand in hand.
Good.
And yours is establishing a uniformity of the way we have magistrates in Texas.
Yes.
Instead of a patchwork quilt.
Yes, that was.
But the reason for moving of this bill is to ensure that the court has the authority to increase the number
of
magistrates,
Okay.
but as far as the actual function. That would.
Okay, great. I just want to make sure we can work.
Yes, ma'am. I hope that explanation is satisfactory.
Perfect. Thank you. Yes, sir.
Members, are there any further questions of Chairman Flores at this time? Okay. We'll move on then to invited testimony. And the chair now calls Bell County Judge David Blackburn. Judge, thank you for being here. If you would mind stating your name and official position and for the record, please.
Yes, sir. Thank you, Mr. Vice Chair, for the opportunity to be here. My name is David Blackburn. I'm the Bell County Judge, and I'm here in support of SB 251. Again, thank you for the opportunity to be here. In Bell County, we have had a process in place over the past several years, maybe decades, where our justices of the peace have performed magistration duties across the county. We have 6 justices of the peace. Historically, the JPs have provided magistration services on a rotational basis, especially for after hours and on weekends. And that has worked well for years. However, as Senator Flores pointed out, over the past few years, our dockets, our caseloads for our JPs have increased to the point where that's become difficult to maintain that rotation. And this has led to fewer JPs on the rotation, and it's exacerbated both by their workloads and an imbalance in workloads within their dockets. About a year and a half ago, we started recognizing this issue and being very significant, as the committee probably knows. If we don't provide magistration, that presents a severe issue for the criminal justice system. So magistration just has to be performed. So what we did, the Commissioner's Court authorized and funded the creation of 2 associate district judges, to which there was an allowance in state law for those associate positions to be created. Working with our administrative district judges, we reached an agreement that one of those associate district judges would be dedicated Monday through Friday, 8 to 5 for magistration work. After hours and weekends would still be handled by a rotation of the JPs, and additional funding was authorized to help supplement the JP's pay for doing that after hours and weekend work, in addition to the new associate judge's position and one dedicated to this. All of this was done and was presented to the Commissioner's Court as an interim measure, interim until we could get legislation in place establishing a magistrate court. If and when the magistration court is authorized, then the Commissioner's Court would appoint a full-time magistrate and support staff and personnel to help carry out those magistration duties across the county. We think that's going to be the most efficient and best long-term measure to deal with magistration in the county. Our county's approaching 400,000 in population, and the dockets have just gotten substantial for all of the judges, and we're seeing a healthy increase in our inmate population in the jail. SB 251 is the bill you have in front of you that authorizes the establishment of this magistrate court for Bell County. We're not asking for any state funding associated with this. The county will absorb the cost for this. We believe the magistrate court will better serve our residents in Bell County. I certainly offer my support for the bill. I did have an opportunity to review quickly the bill that was referenced earlier by Senator Huffman. I don't think there presents any conflicts with what we're proposing. I think your bill attempts to identify and standardize qualifications for magistrates. We would be very supportive of that. Thank you for the opportunity to be here.
Judge, thank you for being here. Members, are there any questions? All right. Thank you very much for being here, sir. Appreciate it very much. We'll now move on to public testimony.
No one here.
Is there anyone wishing to testify on, for, or against Senate Bill 251? Hearing none, testimony is officially closed. Senator Flores moves that Senate Bill 251 be reported favorably to the full Senate with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Aye.
Senator King. Senator Hagenbu.
Aye.
Local.
6 ayes.
There being 6 ayes and 0 nays, SB 251 will be reported favorably to the full Senate here immediately. We also have a motion from Senator Hagenbu.
Local.
Local. Any objection? Hearing none.
608.
Chair now calls up Senate Bill 608 and recognizes Senator Flores to explain his bill.
Thank you, Mr. Chairman, members. For the last few years, the legislature has taken action to improve the processing of evidence collection kits. Forensic labs have improved their ability to process these kits. However, the need for additional oversight is necessary to ensure that the labs are keeping up with state law. The bill would require sexual assault response teams to provide data in their biennial reporting of the number of sexual assault forensic exam kits that are overdue for transfer to a crime lab. The bill would require DPS disclosure of this data in their annual statewide electronic tracking system reports of the legislature. In 2019, the legislature passed House Bill 8, which requires a specific timeline for the collection and analyzing of sexual assault evidence. The bill states that law enforcement agencies must take possession of such evidence within 7 days of being notified by health care facilities, or they are allowed 14 days if they are located more than 100 miles from the health care facility. DPS reports that 119 sexual assault kits are in healthcare facilities that are past the 7-day statutory timeline for taking possession. Each of the kits represents a Texan who was sexually assaulted and is awaiting justice. The lack of urgency is a violation of the law and an egregious violation of the survivor's rights. So I thank you for consideration of this bill, and I'm open for any questions.
Thank you, Mr. Chairman. Members, are there any questions this time of Senator Flores? All right. Then we'll go ahead and move on here with invited testimony. Chair now calls Ashley Brooks and Alice Amelot. Thank you both very much for being here. Why don't we go ahead and start with Ashley, and if you wouldn't mind stating your name and official position and affiliation, please, for the record.
Sure. Good morning, Chair Flores and committee members. My name is Ashley Brooks, and I'm the Senior Policy Advisor with the Texas Association Against Sexual Assault. I am here today to testify in support of SB 608 on behalf of my organization's membership of sexual assault programs and survivors who seek to eliminate sexual violence in Texas. The idea that there's even one uncollected rape kit out there should be disheartening, especially to the legislature, who has spent multiple sessions and millions of dollars improving the collection, preservation, and testing of rape kits. That one uncollected rape kit could have identifying information of a serial rapist. Not to mention the injustice done to the victim, who went through a multi-hour invasive process of getting a rape kit done, only to have law enforcement not pick up the evidence. While Section 420 of the Government Code states that failure of law enforcement to comply with the requirements of collecting, preserving, and tracking rape kits may be used to determine eligibility for receiving grants from the state, to the best of my knowledge, that enforcement mechanism has not been utilized. Rightfully so. SB 608 is our next best option. We're hopeful that by identifying where these uncollected kits are located, the legislature and local officials will be able to address this directly with law enforcement. Thank you for your time, and we appreciate you authoring this important legislation.
Thank you for being here.
Appreciate you very much being here. Members, other questions this time of Ashley Brooks? Thank you very much for your testimony.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the Senate Criminal Justice Committee. I'm Alice Amelot. I'm Assistant Chief of the Crime Laboratory Division at the Texas Department of Public Safety. In this capacity, I represent approximately 700 dedicated professional scientists and staff at our 16 crime lab locations who support law enforcement and criminal justice system across the state. I've been invited to provide testimony today. I want to thank the committee, senators, and staff for your support and your efforts for the Texas Department of Public Safety, specifically associated with sexual assault kit tracking. As you mentioned, the Track It program began September 1, 2019. Statute required DPS to develop and implement a statewide electronic tracking system for evidence collected in cases involving sexual assault. Participation in the tracking system is required by any entity that collects evidence of sexual assaults or other sex offenses, or investigates or prosecutes such offenses. Law enforcement has 7 days to pick up, or 14 days if the medical facility is further than 100 miles, and they get an additional 30 days to submit that evidence to the crime lab. As of Thursday, March 14th, Our department is tracking 56,385 kits. As of that date, the software showed 173 kits in medical facilities past due for pickup from the medical facility. The software counts kits over 40 days as past due. However, for the list and the number that you mentioned, we subtracted those for which the medical facility communicated that those kits have been picked up, so that number past due drops to 119 kits. Those are assigned to 81 different law enforcement agencies. If the law enforcement agency doesn't log into the system and receive the kit and track it, the kit will appear in the software as though it's still with the medical facility. Quarterly, DPS contacts each law enforcement agency with kits past due to the laboratory, which includes kits remaining at medical facilities and kits stored with law enforcement. We specifically reach out via email and phone calls. If we go back to the data we pulled starting in 2021, we had 102 kits past due for officer pickup at that time, 90 kits in 2022, 104 kits in 2023, and 98 kits in 2024. It is very rare for a medical facility to report to us that a law enforcement agency refuses to pick up kits. There are 5 primary reasons that they have provided to us. DPS has reviewed the bill. We believe that there will be no fiscal impact to include the kits for which a law enforcement agency hasn't taken possession of in our annual report. Senate Bill 608 supports the DPS mission of protecting and serving Texas by providing data to facilitate the delivery of sexual assault evidence in a timely fashion to the crime laboratories. And with that, I'm available to answer any questions you may have.
Members, are there any questions? Yes, Senator Hagenbu.
Thank you for your testimony, both of you. Thank you, Mr. Chairman. I'm trying to understand the numbers here. So it was 119 where actual didn't get reported or didn't get processed, I guess, right?
They didn't get picked up.
Didn't get picked up
by law enforcement
right.
as of Thursday.
And then you went through the previous years, and the numbers were comparable for those years. So
Correct.
by my math, that's out of 56,000, that's less than 1%. That's like 0.2%. So is this a 0.2% problem we're talking about, or am I misunderstanding this?
That is the math. We would articulate that every sexual assault kit needs to be processed through
and
the
I agree with that. So it's important anyways. But that just gives a sense of it's a problem, but it's somewhat limited, but still important. I appreciate it. Thank you.
You're welcome.
Well, thank you for your testimony. Thank you for your leadership of such a critical part of our society, and appreciate all you do. So, thank you.
Sir.
Okay. We'll now conclude our invited testimony, and now we'll move forward with public testimony. And the chair now calls Paula Marks to come forward, please. Thank you. Welcome. And if you wouldn't mind stating your name and affiliation and position on the bill for the record, please, ma'am.
Yeah, good morning. My name is Paula Marks. I'm the Director of Forensic Nursing at the Safe Alliance in Austin, Texas. I'm here as a resource for any questions related from the healthcare setting related to this bill.
Members, are there any questions for Ms. Marks at this time? Let me just ask you one general question with your expertise, obviously, looking at the bill, hearing, obviously, understanding what it does. Is it doing everything it possibly can? Are there other things that we should be looking at in this bill, or you feel it's comprehensive?
From what I've read, I feel like it's comprehensive to address the issues. Like I said, we are very lucky in Austin, Travis County. We're not facing these types of issues. I'm here to represent the collaboration that can happen between, all of that. So this bill, I think, could help with that collaboration.
Okay, very good. Well, thank you very much for your testimony. Members, are there any further questions? Very good. Thank you very much for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 608? Hearing none, testimony is officially closed. Senator Hagenbu moves that Senate Bill 608 be reported to the full Senate with the recommendation that it do pass favorably and be printed. The clerk will call the roll.
Vice Chair Parker,
Aye.
Chair Flores,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
No.
5 ayes.
There being 5 ayes and 0 nays, SB 608 will be reported to the full Senate with a favorable recommendation. So we do have like the motion to move Senate Bill 608 to the local calendar. Any objection? Hearing none, shall be ordered. Okay.
I'll get your bills.
Thank you, sir.
Which one's up? Thank you, Vice Chair Parker, and return the gavel. The chair will now hear Senate Bill 955 and recognize Senator Parker to explain the bill.
Thank you, Mr. Chairman and members. I appreciate the opportunity to come before you here this morning and talk about Senate Bill 955. 955 seeks to enhance the penalty for traffickers who recruit their victims from jails or correctional facilities. As you all are aware, human trafficking is a very significant problem in Texas, with our state ranking second in the nation for the number of reported cases. I want Texas to be number one in all things, but certainly not in this, members. Traffickers use various tactics to lure and control their victims, including recruitment from vulnerable populations such as homeless individuals, runaways, and foster children. Some traffickers take advantage of their victims' vulnerable and isolated status by recruiting them from jails or correctional facilities. This type of recruitment is particularly heinous, as victims are already in a vulnerable and restricted environment with limited options for escape or assistance. Enhancing the penalty for traffickers who engage in this type of criminal activity can help deter such behavior and send a clear message that will absolutely not be tolerated here in Texas. By increasing the punishment to a first-degree felony for these offenses, we can better protect vulnerable populations and hold traffickers accountable for their heinous crimes. Senate Bill 955 also corrects a drafting error that created duplicative language back in Penal Code 20A.02b. And with that, Mr. Chairman, I'll conclude my layout. Happy to answer any questions.
Members, are there any questions? Sounds like it. We now invited testimony for Senate Bill 955 is open. We invite Detective Joseph Scaramucci.
Good morning, or afternoon. Well, still morning, Chairman, members of the committee. Feels like it's already afternoon.
We all wonder ourselves.
Thank you for the opportunity to speak with you today. My name, as I said earlier, is Joe Scaramucci. I'm currently the Director of Law Enforcement Training and Operations for a sex trafficking nonprofit called SGS Incorporated. I currently maintain law enforcement credentials, and in 2023, I retired from the McLennan County Sheriff's Office up in Waco. While there, I created our human trafficking unit, which has been recognized both nationally and internationally in our efforts to combat human trafficking and sexual exploitation. Further, contract as liaison for federally funded task forces to assist with training and technical assistance for most major task forces throughout the United States. I've been blessed to be able to arrest traffickers and exploiters and help provide paths to freedom for survivors in every corner of the country, as well as around the world. I'm here to express my support and to express my strong support for Senate Bill 955. Trafficking is not a one-time crime. It's a system of ongoing abuse, coercion, and violence that destroys lives. I've personally witnessed victims' lives, including children who were recruited from shelters, foster care, and even correctional facilities, places where they should have been protected, not preyed upon. Traffickers specifically target vulnerable individuals, exploiting their need for safety and stability. This bill recognizes that reality and strengthens penalties against those who commit these horrific crimes. Senate Bill 955 increases the punishment for traffickers who recruit victims from correctional institutions, women and men who are all in unique positions of vulnerability. Traffickers oftentimes use their incarcerated victims, or they themselves recruit from correctional facilities using the lure of a better life, secure housing, easy transitions into freedom, and even their constitutional right to bond as ways to grasp control over their lives. The provisions of this bill send a clear message. In Texas, we will not tolerate the ruthless exploitation of our most at-risk populations. We work to rehabilitate and reduce recidivism, not provide those seeking to exploit with a playground to hunt their next victim. Throughout my career, I've seen the devastating effects of human trafficking. Victims suffer years of trauma, physical abuse, and psychological control. Many never escape the cycle of exploitation because traffickers operate with impunity, knowing that the legal system often struggles to hold them fully accountable. By passing Senate Bill 955, we give law enforcement prosecutors stronger tools to dismantle trafficking networks and put the worst offenders behind bars for decades. This is not just about punishment, it's about prevention. When we impose severe consequences on traffickers, we deter future crimes. When we recognize that targeting not only shelters and schools, but also correctional facilities is an especially heinous act, we take a stand for justice. When we strengthen penalties for those who use violence, manipulation, and intimidation to control their victims, we send a clear message that Texas is a state that protects the vulnerable and punishes the wicked. I urge you to pass Senate Bill 955. Survivors of trafficking deserve justice, and our communities deserve protection. Thank you.
Thank you for being here. Any questions, members? Thank you very much for taking the time to be here.
Just a comment.
Senator Hagenbuch.
Just want to thank you for your testimony. And the second time, you did a great job. Obviously, you're very good at your job. It's such an important job. And I just want to thank you, Senator Parker, for in your work on trafficking. We don't want to be number one. Absolutely, we want to be last. We want to eradicate it if we can. But it's called what it is. It's modern day slavery, and there shouldn't be any. And by some things I've seen worldwide with this kind of thing going on, we may have the most slaves in any time in history. I'm not sure that's true, but it's a terrible problem, and I just appreciate your work on it, and I really appreciate your work in Texas on it.
Thank you, Senator.
Thank you.
Thank you for testifying.
Thank you
for being here.
Seeing no other invited witnesses on this bill, invited testimony is now closed. Chair now opens for public testimony. Chair invites Susie Kennan. Susie Kennan. Thank you. Is there anyone else present on, for, or against Senate Bill 955? Not. Public testimony is closed. Senator Parker moves that Senate Bill 955 be reported to the full Senate with the recommendation to do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbuch.
Aye.
4 ayes.
There be 4 ayes, 0 nays. Senate Bill 955 will be reported to the full Senate with a favorable recommendation. Senator Hinojosa moves that Senate Bill 955 be referred to local and uncontested. Any objection? Hearing none. So ordered. Chair lays out Senate Bill 957 and recognizes Senator Parker to explain the bill.
Again, thank you, Mr. Chairman, members, for allowing me to lay out these bills that work to address the horrible challenges with human trafficking, such an important thing that we as a legislative body, as a Senate, continue to be vigilant and making certain that we do everything in our power to end trafficking. A particularly notorious aspect is the rapidly repeated nature of the crime. Traffickers sell their victims over and over and over again, day in and day out. They are commonly picked up by law enforcement, let out on lenient bail because their finances are hidden within their organized networks, and within days are back out selling their victims again. Prosecutors have expressed that under current law, the prosecutor must choose a specific date of an incident of promoting prostitution and show 2 or more incidents on that specific date. That proves to be challenging because traffickers recruit and traffic victims throughout a period of time. Senate Bill 957 would allow the jury to have important evidence of the traffickers' recruiting, managing, and financing of their operation. Current law only gives a snapshot of a specific date and time. A broader view is needed in order to encapsulate the scope of a trafficker's total enterprise and what they're doing broadly. Senate Bill 957 seeks to address this problem by creating a new offense of continuous, aggravated promotion of prostitution. This bill targets only the individuals who operate or manage a prostitution enterprise involving 2 or more victims over a period of 30 days or more. It allows a jury to convict without unanimous agreement on specific acts or dates, as long as they agree that the crime occurred over the required time frame. The offense is classified as a first-degree felony, carrying a sentence of 25 years to life in prison. With that, Mr. Chairman, I'll conclude my opening remarks. Be happy to answer any questions.
Senator Hinojosa.
Thank you, Mr. Chairman. While I do support the bill, Senator Parker, I do have a question. I read the bill, but in the explanation and the background and you explained the bill, it says it does not require a prosecutor to prove force, fraud, or coercion. It's required under the continuous human trafficking statute. So we're not doing away with intent, are we?
No, we're not getting away with intent. All we're trying to do right now, the current situation is so prescriptive and tight at a specific instance that you're trying to capture in order to be able to get this type of offense. And so all we're trying to do is broaden that time frame, if you will, to encapsulate and show all of this bad behavior. So there's clearly, you'll see the intent, all the different things that they're doing. The full criminal enterprise will be on display just over a longer period of time, Mr. Chairman.
Well, and I really understand the bill itself, and as you so well explained it, it allows the jury to convict without unanimous agreement on specific acts or dates, as long as they are agreed that the crimes occurred over the required time frame. I don't have any problems with that. I'm just trying to find in the bill itself where it talks about it does not require a prosecutor to prove force, fraud, coercion. It's not in the bill itself, so it's a little bit confusion on that.
No, fair. Thank you, Mr. Chairman. I think the witness could shed some light on that as well. We got some great witnesses, and then we'll come back and talk about it a little further.
Yes, sir.
Thank you.
Any other questions? With that, invited testimony on Senate Bill 957 is now open. The chair calls Lindy Borchardt and Joseph Scaramucci. Ms. Borchardt?
Thank you. Good morning, Chairman, members of the committee. I'm Lindy Borchardt. I'm here individually in support of SB 957. I'm a former prosecutor with 30 years of experience. The last 5 years, I had the privilege of being the human trafficking prosecutor for the Tarrant County Criminal District Attorney's Office. And it was during this time that I was prosecuting human traffickers that I saw a need for Senate Bill 957. Thank you to Vice Chair Parker for bringing this bill and getting it filed. First of all, Senator Hinojosa, let me address your concerns. There's absolutely still an intent. In this, the prosecutor has to prove that the person knowingly owns, invests in, finances, controls, supervises, or manages a prostitution enterprise that uses 2 or more prostitutes. So I have to, as a prosecutor, prove beyond a reasonable doubt that that person knowingly operates a prostitution enterprise. And that is what is different than the human trafficking statute. If it's an adult, the prosecutor has to show through force, fraud, or coercion, or for compelling prostitution, force, fraud, coercion, or threat. But this is a different type of crime. This is the crime of knowingly managing a prostitution enterprise. And during my time as a human trafficking prosecutor, I saw this need for this bill come up time and time again. One case that comes to mind, it was the defendant that had managed a prostitution enterprise for well over a year. There were 9 victims that we were able to identify. And in these types of cases, the victims, the women, are in and out. They're able to leave, and then through manipulation, they're coming back into the prostitution enterprise. And it was at this time I realized the importance that a jury see the full scope of the prostitution enterprise, because the full scope shows the recruitment. The full scope shows how he's financing it through numerous Cash App applications where money is going back and forth through the men that are paying to have sex with these women. And this is similar to a lot of our other continuous statutes. We have continuous sexual abuse of children, continuous family violence, continuous human trafficking. And it's because we have these other continuous offenses, it was the need that was shown that the jury see the entire scope of the criminal offense. Because until the jury sees the entire scope of the prostitution enterprise, are they in the position to truly render justice to the victims of that prostitution enterprise? And that is what's so critical about this bill. There are safeguards in place, just like there's safeguards in place in all our other continuous statutes that we see in the penal code. But this bill is important so the jury can see the entire scope of the prostitution enterprise. And let me tell you, it's pretty horrific. The recruitment that goes on, the manipulation that goes on that might not rise to the level of forced fraud or coercion, but it's still there for the adults. And so this is why this Senate bill is so important, and I appreciate being here today, and I welcome answering any further questions that you have on this bill.
Thank you for your explanation.
You're welcome.
She does an incredible job with that, doesn't she? All the years of experience in the field, right?
It comes in handy. But
Absolutely.
it's nothing like coming before you, let me tell you. I'd rather be before a jury.
Detective?
Good morning. I'm not going to belabor my introduction again. My name is Joseph Scaramucci. Obviously, I'm retired law enforcement. I work for a counter-sex trafficking nonprofit. I'm here to obviously support very strongly the Senate Bill 957. Throughout my career, I've seen firsthand the devastating impacts of human trafficking, particularly when it comes to forced prostitution. Traffickers do not simply exploit their victims once and then move on. They subject them to continuous, prolonged abuse, trapping them in cycles of coercion, violence, and fear. These criminals do not stop after a single act. They continue their operations day after day, month after month, and year after year, profiting off the suffering of others. Senate Bill 957 directly targets this pattern of exploitation by creating the offense of continuous aggravated promotion of prostitution. This law will ensure that those who engage in the ongoing recruitment, enticement, and exploitation of multiple victims face serious consequences. Under this bill, traffickers who repeatedly force individuals into prostitution over a period of 30 days or more will face first-degree felony charges with a minimum sentence of 25 years. This level of accountability is absolutely necessary. It recognizes the reality of these crimes and the severity of harm inflicted on victims. One of the biggest difficulties in holding sex traffickers accountable under Chapter 20A of the Human Trafficking Penal Code is the proof of force, fraud, and coercion. While it is always there, the reluctancy of victims to articulate it means it's often incredibly difficult to prove. This bill would be a trend-setting solution and would give voice to the voiceless. I've witnessed too many cases where traffickers escape with little to no punishment while their victims are left with the lifelong trauma, criminal records, and no path to recovery. This bill sends a clear message that Texans will not tolerate those who make a business out of enslaving and exploiting others. It aligns our laws with the lived reality of victims and ensures that we are targeting the true perpetrators, traffickers, not the individuals they victimize. Passing Senate Bill 957 is not just a legal decision, it's a moral imperative. We must give law enforcement and prosecutors the tools needed to dismantle trafficking networks and ensure justice for those who have suffered. I urge you to support this bill and stand with survivors who need our protection. Thank you.
Thank you. Members, any questions? Any questions? So seeing no other invited witnesses on this bill, invited testimony is now closed. Thank you.
Thank you both very much.
Public. The chair now opens public testimony. We see no one has signed up. Is anyone here on, for, or against Senate Bill 955? Seeing none, public testimony, 57, excuse me. Public testimony is now closed. So Senator Parker moves that Senator Parker moves that Senate Bill 957 be reported to the full Senate with a recommendation that do pass favorably be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman, Senator Miles, Senator King, Senator Hagenbu.
Aye.
4 ayes.
There be 4 ayes and 0 nays. Senate Bill 957 be reported to the full Senate with a favorable recommendation. Senator Hagenbooth moves that it be considered for local non-contested. Any objection? Hearing none, so granted. That's it? Wait a second. So members, we have 4 motions in writing with Senator Parker, Senator Miles, and Senator King, Senator Hagenwu, and Senator Huffman. They do not affect the outcome of the votes. We're entering them into the record. Any objection? None. Hearing none. So entered. Members, is there any business any other business to come before the committee at this time? Hearing none, Senator Parker moves that the committee stand in recess, subject to the call of the chair. Thank you, members. Thank you all very much.
Thank you, Mr. Chairman.